that actually is based on two aspects. One is related to the wonderful work conducted by Physicians for Human Rights, and I'm very glad that Professor Shaul Dolberg is with us, also a board member. It's also related to a broader initiative that maybe we have time to discuss. I won't discuss it too much in the paper, but it's about the Israeli health, the prison health services, and I'm glad that I hope that the next session Dr. Liav Goldstein would be here, and maybe he's here. Hi, Liav, and I think it's really great that we can have a dialogue about the Israeli prison health services in general, and about a question of dual loyalty that are relevant there. But in my presentation here, I present more a theoretical framework that especially Danny, Phil, and me are presenting. Some of you, especially the Safra Center, already know quite a lot about it, and it's a way of moving ahead, moving forward from the so-called traditional bioethics perspective. So by the end of April 2012, more than 1,600 Palestinian prisoners in Israeli jails had begun a mass hunger strike. The strikes aim to achieve two main specific goals: the end of isolation and solitary confinement of Palestinian prisoners, and the restatement of family visits. The prisoners also demanded access to better quality medical treatment, access to higher education, an end to forced strip searches, and an end to disproportionate punishment. A few months later, reflecting on the ethical dilemma posed to the medical profession by the prisoners' hunger strike, Professor Avinoam Reches, then the chairperson of the Israeli Medical Association Ethics Committee, called for a joint action of the Ministry of Justice, Ministry of Health, and the Israeli Medical Association and human rights organizations. He called on them to work together in order to formulate a treatment policy for hunger strikers in Israeli prisons, thus avoiding putting all the pressure of difficult decisions on the individual physician. In arguing for his proposal, Reches depicted the main ethical dilemma for the physician as a choice between respecting the rights of the patient, the hunger striking prisoners, and autonomy and the sanctity of life. And I'm quoting, "This is a collision between two basic ethical principles: the value of autonomy and the right of the individual to decide on his body, up to the point that he can commit suicide as an expression of his free will, and the value of sanctity of life, which for its supporters weighs more than the desire to die by any means, including by hunger." In posing the ethical dilemma facing physicians as the tension between the principle of individual autonomy and the sanctity of life, Reches adopts the same liberal perspective that inspires the Malta Declaration from 2006, signed also by Israel, which broadly replaced the question of how physicians should act in cases of hunger strikes in the context of the tension between two fundamental bioethical principles: autonomy versus sanctity of life. The declaration gave clear priority to the former, thus disallowing the practice of force feeding. While the tension between these two principles is undoubtedly one of the central dilemmas presented to health practitioners dealing with hunger strikes, we want to argue that limiting the ethical question to this tension obstructs and limits the ethical discussion, and maybe you heard already from the previous paper some of going this direction. So in this paper, we want to develop an approach to ethical dilemma faced by healthcare providers and also healthcare system as a whole, treating hunger strike prisoners based on a civic Republican perspective. From this point of view, the decision of prisoners to hunger strike is entitled to protection not just because of individual autonomy stands at the top of a supposedly universal scale of values, but because hunger strikes are an expression of a collective action aimed to modify the unequal distribution of power that hinders self-government and individual and collective fulfillment. Thus, we argue that professional ethics mandate that the physician will side with the patient. While the prisoner is still conscious, healthcare providers must respect the hunger strikers' wish to refrain from eating, not only because they should not interfere with the prisoner's autonomous decision, but grounded on the Republican understanding of the value of civic action within a political community. When the prisoner is no longer conscious, the decision must be informed by past discussions and agreement with the patient, thereby approaching the issue as a complex balance between respect for individual autonomy, the sanctity of life, and respect for the strike as a civic action. The liberal perspective that focuses on the individual dilemma tends to be oblivious to the asymmetrical relation of power that characterize the prison system and to the socio-political context in which hunger strikes take place. The liberal perspective poses a problem in similar terms to the ethical dilemma facing a doctor whose patient refuses a life-saving procedure. However, as Reches himself noted, the relation between physician and his hunger-striking patient is not a typical doctor-patient encounter. The patient is there against his or her will, and the prisoner is treated by a physician he did not choose, at least in the first instance. Moreover, the physician usually makes his choices torn apart from loyalty for his patient and for the system in which he works. Finally, the prisoner is not just refusing treatment. Hunger striking is a political act. Thus, the ethical discussion on hunger strikes cannot limit itself to reproduce discussion of traditional dilemma common in the so-called normal clinical setting, where a patient grounds his refusal to a life-saving procedure or treatment in the right to individual autonomy. Hunger strikers should not be simplistically compared to a patient willingly avoiding medical treatment that can alleviate his or her suffering. Hunger strikers do not choose death over life, neither do they want to put necessarily an end to their lives. Theirs is a political struggle in which, even though they are prepared to risk life, they would gladly go on living if they achieve their goals. Bilal Diab, who was released from administrative imprisonment in an Israeli prison after 66 days of hunger strike, exemplified this when saying, and I'm quote, "No one dies for the sake of dying. No one becomes a martyr for the sake of dying. We love life in its natural form. A hunger strike is a real struggle which the person undertakes and risks his life in order to be released and given freedom." End quote. Emphasizing hunger strikes as a political act implies that health practitioners' conducts cannot be analyzed only through the prism of clinical medical ethics. It requires a public health ethics approach, an approach that understands health in the context of the complex relationship between society, state, organizations, communities, and individuals. So this is the perspective we adopted in the present paper. When we want to present an alternative to the liberal framing of the ethical dilemmas, one in which the individual physician must choose between respecting the prisoner's individual autonomy and the sanctity of life. So, in the time I have here, I want to move to the specific case of the Israeli prison setting, and also the reaction of the Ministry of Health and the Israeli Medical Association to present the dilemma here. So in order to illuminate the political context in which public health ethical dilemma concerning hunger strikers emerge, both at the macro and micro level, I want to discuss the case of Palestinian hunger strikes in Israeli jails. I will present the institutional prison setting and then discuss the ambivalence and internal contradiction in the approaches of the two main healthcare professional institutions, the Ministry of Health and the Israeli Medical Association. So in Israel, health and medical services provided to prisoners are not included in the national health insurance law that regulates provision of services for all citizens and legal residents. By the way, similar to what is going on in the Israeli military, in the IDF. Prisoners' health care services fall under the Public Health Ordinance 1940, a regulation dating from the days of the British Mandate. The medical personnel working in the prison system are not employed by the Ministry of Health or public sick funds. Physicians work full-time for the Israeli Prison Service and are employed either directly by the Israel Prison Service or through manpower firms. Since they are totally dependent on the Israeli Prison Service for their livelihood, they find themselves in a perpetual situation of dual loyalty. Same thing also in the military and other places, but again, the dual loyalty today would be less of a main focus, including in the case of hunger strikes. The problematic situation of physicians whose loyalty to the patient is eroded by the circumstances as employees of the IPS could be partially countered by allowing hunger striker prisoners to consult with independent physicians of their choice. However, during the 2012 hunger strike, the IPS did not allow independent physicians to examine and monitor the hunger strikers. When the court allowed sporadic visits of independent physicians who enjoyed the trust of prisoners, in most cases the IPS medical system did not cooperate and refused to transfer relevant medical information as required in Israel by the Patients' Rights Law. The IPS attorney answered to the court in the case of a petition of one of the Palestinian hunger strikers, Tahir Halala, to allow a physician of his choice to visit him in prison, made clear that the main reason for which the IPS wants to maintain a monopoly on prisoners' medical care is keep control over them. The IPS attorney wrote, and I'm quoting, "The physician visit may be intended for the prisoner themselves, but they have not medical value. What we are seeing at present is a phenomenon that is becoming widespread, end quote. As far as the IPS is concerned, requesting the entry of independent physicians, that is, physicians not employed by the prison system and chosen by the prisoners themselves to treat administrative detainees on hunger strikes, and I'm quoting, is analogous to an attempt to wrest control from the IPS. Thus, even in cases in which an Israeli court ordered IPS to allow visits by independent physicians, the service insisted that those visits take place in presence of IPS staff, thereby violating patient privacy, undermining the basic condition of medical encounter. Now I want to move to the Israeli Ministry of Health and the tension between healthcare and the law. In mid-April 2012, the Ministry of Health distributed guidelines for handling hunger strikers, which dealt mainly with parameters for treatment. The guidelines did not enforce force feeding, but neglected to emphasize the rights of the hunger striker to independent medical advice, medical privacy, confidentiality, and access to all relevant medical information. After the countrywide 2012 strike, the Ministry of Health adopted contradictory positions. On one hand, in January 2013, the ministry distributed a memorandum in which it recommended transferring every prisoner hunger striking for more than 28 days to the public healthcare system, a position opposed to that of the IPS. On the other hand, the Ministry of Health collaborated with the Ministry of Justice in elaborating a bill that would entitle the district court to order force feeding of hunger striking prisoners. The proposal established that the judge's decision supersedes the patient's rights law, which forbids treatment without informed consent. The proposal also abolished the option of suing physicians who participated in force feeding, if ordered by the court. Following the example of the United States, the bill establishes that in order to arrive at a decision, the judge will take into account not only the prisoner's health and the dangers of the proposed treatment, but also considerations related to national security and public peace and the influence of the decision on the IPS ability to maintain order. The proposed bill explicitly states that if the prisoner does not accept the treatment, guards are allowed to use force. While the individual physician may refuse to participate in force feeding based on medical ethical considerations, those who agree will be protected from legal accountability. Moreover, based on security considerations, the judge can arrive at his or her decision without the presence of the prisoner or his or her attorney, basing the decision on undisclosed materials. The proposed bill is clearly not in line with the health profession ethics as expressed in the Malta Declaration. The fact that the Ministry of Health played a significant role in drawing the bill emphasized the tension between its professional role and being part of the state. In order to understand the contradiction in the Ministry of Health approach, we need to analyze it within a theoretical framework that repoliticizes the topic, taking into account both the socio-political context and institutional framework. The contradictory policies of the Ministry of Health result from the tension between its professional commitment to the ethics of healthcare and its role as part of the state apparatus. As such, it involved in the political struggle resulting from the occupation, a role that transcends the individual ethical preference of healthcare practitioners that have executive roles in the Ministry of Health. And now to the final protagonist, the Israeli Medical Association. And we call it ethical ambivalence. The role played by the Israeli Medical Association in public discussion concerning Palestinian hunger strikers has been more ambivalent. On one hand, the IMA states that it will stand by physicians in the IPS facing dual loyalty, who will abide by their unethical mandate against employer orders. The IMA also publicly opposed the Ministry of Health memorandum requiring the hospitalization of prisoner hunger striking more than 28 days for fear that it could be used to justify forced treatment. Concerning force feeding, the IMA analyzes the issue in accord with the Malta Declaration, making clear that hunger strikers are not suicidal. Moreover, the IMA dedicates a broad discussion to the topic in its meeting as reflected on its website. The IMA stated, and I'm quoting, "In ideal situation, prisoners are entitled to consult independent physicians. However, the term ideal functions as a caveat, and during the 2012 hunger strike, the IMA did not make a public stand advocating for the right of the prisoner to consult independent physician or to be hospitalized in civil facilities. The predisposition to accept force feeding is grounded not only in the sanctity of the prisoner's life, but also in their readiness to include security consideration in the evaluation." The influence of the latter is clear in the IMA approach toward, and I'm quoting, the more resolute hunger strikers. The IMA document states, quoting, "It seems that the logical ethical approach in those cases is to follow the international guidelines and refrain from influencing the hunger strikers to put an end to his or her strike. Previous experience teaches us that this is not easy, especially in the case of more political hunger strikers. While in the most cases medical paternalism is improper, there are situations in which the physician must adopt a paternalistic approach. This is a quote from the Israeli Medical Association. In an almost unconscious way, this statement brings to the fore the limitations of the liberal ethic approach. When push comes to shove, when hunger strikers are more political, the IMA finds it difficult to act according to the logical, and I'm saying liberal, approach that gives preference to individual autonomy. Moreover, for the Israeli Medical Association, the urge to convince hunger strikers is not related to the degree of danger to their life, but to the question of whether the struggle is more political, that is, challenging the current unequal distribution of power resources. So to conclude, only within a theoretical perspective that recognizes the fact that individual preferences are embedded in the social structure with its unequal distribution of power and resources, and emerging as a result of the interplay between different institutions, can we account for the contradictory stance of both the Ministry of Health and the Israeli Medical Association. Those contradictory approaches do not emerge from the tension between the principle of autonomy and the idea of sanctity of life, as usually is presented, but relate to the complex interrelation between ethics, politics, and power. Thus, we must take this interrelation into account in order to be able to thoroughly discuss the ethical questions posed by prisoners' hunger strikes. Thank you.